One law, passed in 2018, has resulted in over $5 billion in fines against some of the most powerful companies in the world. Meta, Google, TikTok, LinkedIn, Amazon, all fined, some multiple times. It's called GDPR, and while most people have heard of it, very few actually know what it is, what it does, and why it matters to them personally. Today we fix that. Welcome to the Compliance Edge, where we break down the laws and regulations that shape the world around you. Let's get into it. To understand GDPR, you first need to understand the problem it was built to solve. For most of the internet's history, companies collected personal data with almost no restrictions. They gathered your name, your email, your location, your browsing habits, your purchases, your political views. And they used that data however they wanted. They sold it to advertisers, they shared it with partners, they stored it indefinitely, they rarely told you exactly what they were taking, and they certainly didn't ask for meaningful permission. The result was an industry built on surveillance, one where the product being sold, in most cases, was you. In Europe, this had been a growing concern since the 1990s. An earlier directive from 1995 tried to address it, but it was outdated almost immediately. The internet had grown too fast, the data too valuable, and the companies too powerful. In 2016, the European Union passed the General Data Protection Regulation, GDPR. It gave companies 2 years to prepare, and it came into force in May 2018. For the first time, a major jurisdiction had set clear, enforceable rules for how personal data must be handled, with real penalties for companies that broke them. GDPR is built around a simple idea: your personal data belongs to you. Companies that collect it are acting as custodians of something that isn't theirs. That principle leads to several concrete rights. First, the right to know. Companies must clearly explain what data they collect, why they collect it, and what they do with it. No more buried terms and conditions that nobody reads. Second, the right to consent. Where consent is required, it must be freely given, specific, and unambiguous. Pre-ticked boxes don't count. Vague statements about improving your experience don't count. You have to actively agree. Third, the right of access. You can ask any company what data they hold about you, and they must tell you, within 30 days for free. Fourth, the right to erasure, also called the right to be forgotten. You can ask a company to delete your data, and in most cases, they must comply. Fifth, the right to data portability. You can ask to receive your data in a machine-readable format and take it elsewhere. For example, switching from one service to another without losing your history. Sixth, data minimization. Companies can only collect data that is actually necessary for the stated purpose. Hoarding data just in case is not acceptable. And seventh, security. Companies must protect the data they hold with appropriate technical measures. If there is a breach, they must report it to regulators within 72 hours. This is where GDPR gets sharp. The penalties are deliberately large, designed to hurt even the biggest companies. There are 2 tiers. The lower tier carries fines of up to $10 million or 2% of global annual turnover, whichever is higher. The upper tier, reserved for the most serious violations, carries fines of up to $20 million or 4% of global annual turnover. For a company like Meta, 4% of global turnover is not a symbolic gesture. It is a number in the billions, and regulators have not been shy about using these powers. Google was fined $50 million in France in 2019 for failing to properly explain how it uses data for advertising. Amazon was fined $746 million in Luxembourg in 2021 for behavioral advertising violations. Meta was fined $1.2 billion in Ireland in 2023 for illegally transferring European user data to the United States. TikTok was fined $530 million in Ireland in 2025 for transferring data to China. In total, European regulators have issued over 2,000 fines since 2018. The total value exceeds $5 billion. You might be thinking, this is interesting, but what does it actually do for me? More than most people realize. Because of GDPR, every time you see a cookie consent banner, you have a genuine choice, at least in theory. Because of GDPR, companies operating in Europe have had to redesign their data collection practices and be more transparent about what they take and why. Because of GDPR, a data breach that affects you must be reported, and you have the right to know about it. GDPR has also had what is sometimes called the Brussels effect. Because many companies operate globally and it is easier to apply consistent standards than to maintain separate systems, GDPR has influenced data practices well beyond Europe. Companies in the United States, Asia, and elsewhere have changed their policies to meet European standards, which means that even if you are not a European citizen, you have likely benefited from this law. It is also far from perfect. Enforcement has been uneven. Some regulators have been more aggressive than others. The fines, while large in absolute terms, are often a fraction of the revenue generated by the practices being fined, and consent mechanisms have frequently been designed to make agreeing easier than refusing. But as a framework for data rights, GDPR remains the most consequential piece of privacy legislation ever passed. Over the next few weeks on this channel, we'll be covering specific GDPR cases in depth, including the TikTok fine, the Meta transfers case, and others. Each of them illustrates how this law works in practice and what it costs companies to get it wrong. If you want to stay on top of these stories, subscribe to The Compliance Edge. New videos every week, always free, always breaking down the stories that matter. See you in the next one.